CDBS webinar, March 28th.
Okay, I think I'm going to start recording right now. But thank you very much for coming on to see your first webinar of a series of 4 about IEP. So let me start by saying a few housekeeping rules. The first thing that I'm going to do is say that the people that need Spanish interpretation, they need to click on icon and hit Spanish.
And Myrna, the only other thing that I'll say is, if you're out there listening in English, you could also select the globe icon and select English.
Thank you. So the interpretation is all set. And the second thing is, we have to mute all microphones. Please hold all questions till the end. This webinar will be recorded in our site for future references. So this presentation will be going for about 60 minutes. And at the end we're going to give 15 minutes for question and answer. So at the end, if you need to ask a question, please unmute and ask the question, or if you have something in mind during the presentation, please put it in the chat and then that question will be answered at the end. And any handouts that will be presented will be put in chat. So right now, I'm going to just have the pleasure of introducing a person that I know for some time already. And she is my go-to person every time I encounter a legal situation with the parents that we serve. So I want to welcome Mary Rios. She's a senior disability advocate for over 25 years. She's a multicultural advocate, and her expertise is outreach to the community. And she is Latina with a disability herself, and her passion is advocacy. She works for Disability Rights California, serving the Inland Empire area, and it's a non-profit organization funded in 1978 that defends the rights and opportunities of people with disabilities. Mary has a mantra that says, "Nothing about us without us." So anything else that you want to say about you?
Myrna, you did a great job. I wanted to say that it's not only the Inland Empire. We serve statewide now since we went virtual. We're able to assist any person in the state office California. Thank you, Myrna, and thank you for having me. So are we ready to get started?
Yes, we are.
Thank you, Myrna. Thank you. Thank you everyone for being here, and thank you again for inviting me. Today we're going to cover special education in the IEP process. Again, my name is Mary Rios, and I'm a person with a disability. I use a power chair. I've been in a power chair for over 30 years, and I've been an advocate for over 25 years. It's my passion. I love advocacy. I say making a difference in one person's life is a lot, so if I bring some knowledge to some people, I really enjoy the feedback that I get in knowing that I made or changed a person and their life. So again, we're going to cover special education today. I have my colleague with me, Raymond, who is assisting in the background. So next slide, Raymond. Today's discussion points, we're going to talk about child find mandate and do a brief overview of special ed laws and special education eligibility, and cover Section 504 of the Rehabilitation Act, the special education process, and we're also going to be talk about compliance, complaints, and due process. So what is child find mandate? It means that school districts must locate and find children that may be eligible for special education. Child find mandate covers every child from birth to age 21. The schools must evaluate whether they know or suspect that a child may qualify for special education. Child find applies to all the children to reside in the state of California, including children who attend private schooling, public schools, and migrant children, and homeless children, and children who are wards of the state. So anytime a child has a disability, they do have to initiate the assessment process. So what are special education laws? There is the Individuals with Disabilities Education Act, also known as IDEA. or IDEA. And there are also California state education laws. So the federal law is very broad, and then California state education laws. They either strengthen the federal law within the state of California, but these are the two primary laws that cover special education. So what are IDEA entitlements? The individuals with the disability, a student who qualifies for special education, has a right to free and appropriate public education in a least restrictive environment. They also have the right to assessments and also to an individualized education plan.
To due process. Next slide. So right to free and appropriate public education, FAPE equals specialized academic instruction plus related services, and they are provided at public expense. They must meet the standards of the state educational agency, include appropriate preschool, elementary, or secondary education, and are provided in conformity with the individualized education plan. So that equals FAPE. Next slide, Raymond, thanks. So the least restrictive environment, when we say the least restrictive environment, typically it means that the student has a right to receive special education services in the least restrictive environment. What I see as the least restrictive environment is the general ed class. The school district must look at the general education classroom before they can consider a more restrictive setting to the maximum extent appropriate, with any opportunities for children to interact with children who don't have disabilities. Schools must provide supports to ensure success in the regular education classroom. However, in some situations, it may not be an appropriate placement for some children who have more severe disabilities. Therefore, they have to look at other alternatives. What is special education? Special education is not a place. It is a pool of services available to qualifying students with disabilities that ensure the receipt of a free and appropriate public education. Eligibility, let's talk about eligibility. Who is eligible for special education under federal and state law? Here we have a list of disabilities. There are 13 categories. I'm not going to read them all, but it's having an intellectual disability, speech or language impairment, visual impairment, including blindness, a serious emotional disturbance, autism, other health impairment, specific learning disability, or multiple disabilities. So just because the student may have a disability, it doesn't mean that they qualify for special education. If we go to the next page, what it indicates is all students between the ages of 3 and 22, and when the school districts conduct the assessments, the assessment must demonstrate that the student's impairment adversely impacts his or her educational performance and requires special education. So that is something that the school district also looks for. How does it impact their educational learning? Here we've included chapter 2 that talks about the evaluation process. It's a great chapter. We have great publications on our website, and I'm going to talk more about that in a few minutes. Next slide. So in addition to the special education laws, there are also anti-discrimination federal laws, which is the Section 504 of the Rehabilitation Act of 1973, and there's a Title II of the Americans with Disabilities Act. So these are anti-discrimination laws that protect students with disabilities in public schools as well. So they basically cover any entity that receives public funds. Next slide. So what is a 504 plan? Often for students whose disability does not adversely affect their educational performance, many students may just need a reasonable accommodation and or a modification to benefit from the school's programs. So Section 504 of the Rehabilitation Act prohibits disability discrimination by recipients of federal funds or entities, schools that receive public funds. Section 504 is not based on a categorical analysis of disabilities. Rather, Section 504 protections are available to students who can be regarded as disabled in a functional sense. These students must meet, and there are three sections here, have a physical or mental impairment, or have a record of such impairment, or be regarded as having a disability or an impairment. Next slide. So what is a 504 plan? Students who are eligible under Section 504, in contrast to IEPs under IDA, students and parents may receive fewer protections under a 504 plan. Nonetheless, it provides foundation for disability-based discrimination claims. One thing that I do want to point out is, and a parent asked me this, her son was recently found eligible for special education. So her question to me was, can I also ask for a 504 plan, or does that mean that they'll what the school will do is try to get, try to take them off of the IEP? And I basically know if the student is eligible for special education, they have an IEP, the IEP can include any reasonable accommodations and or modifications in the IEP plan. So that's important to know as well. Next slide. So here we have examples of reasonable accommodations, unaccessible desks for a student in a wheelchair, special seating in the classroom. Maybe the student needs to sit up close to the teacher. They may need to record a lesson, modified homework. If the student is having a really difficult time, parents can ask for modified homework. Let's say, for example, the students get 20 questions as homework, the parents can ask that they modify that homework and give them only 10 questions, 10 homework assignments. So that's a modification that the school district can provide. Maybe they need quiet space for testing or taking a quiz, or they may need extra time. They may need breaks. Throughout the time they're in the classroom. These are accommodations that can be implemented into the IEP or in the 504 plan. So we covered the eligibility process. We covered the laws. Now we're going to talk about the special education process, which is my favorite. Next slide. So when there is a referral, either from a doctor, from a parent, anybody can make a referral to the school district to, if they suspect a student has a disability. So a referral is made. When the referral is made, what we usually advise is that if parents are going to ask the school district to have their child assessed, that they put it in writing. Why do you want to put it in writing? Because you want to create that paper trail. You never know when you're going to need the paper, any documents that, let's say, you ask for a referral and the school doesn't comply within the timelines, you definitely want to create paper trail. So once you submit a request for an assessment, the school district has 15 days to provide you with an assessment plan. The assessment plan will indicate what types of assessments are going to be conducted, who's going to conduct the assessments, and if you agree to the plan, you sign it and you return it. The school district then has 60 days to complete the assessments and hold an IEP meeting. If it's the first IEP, you definitely want to, well, prior to that, what you want to do is you want to ask for a copy of the assessment reports before the IEP meeting. So the IEP meeting takes place, and usually what happens is they have an IEP meeting every year to talk about the placement, to talk about the appropriate supports and services, any related services that are needed. Then what happens is after the annual IEP, it takes place every year. And then they have what's called the triennial IEP, which is the school district should reassess every 3 years. And the reason for the reassessment is to determine if the child still qualifies for special education, to look and see if the placement is appropriate, to see if they need any additional supports and services. Say, for example, they start having difficulty with their hands. They may need additional assessments, such as an occupational therapy assessment. So they do the triennial, again, to see where they're at academically, to see what supports and services are needed. Next slide. Here we have a sample of an assessment plan. It indicates whether it's the initial, the annual, triennial, transition, or other. It's addressed to the parents or the guardian of, and it should indicate the student's name, the date, district, school, and if it was a referral that was made, who made the referral. And then down, if you go to the next slide, we have there are little boxes with different types of assessments that are indicated on here. Academic achievement, health, intellectual development. So there's a series of assessments that are written in the assessment plan. On the right, it indicates who is going to conduct the assessments. Down at the bottom, if you agree to these assessments, you go ahead and you sign it. There's a section on, at least on this example, there is a section for comments. What we usually recommend is anytime there is going to be an assessment completed, you want to include a note that says, please provide copies of the assessments at least 5 days before the IEP meeting. Why do you want to do that? You want to do that because you want to have the opportunity to review the assessments in their entirety. Many times what we hear is that the IEP team or the school district will not provide the parents a copy of the report until the IEP meeting. When that happens, they're not giving parents the opportunity to review the entire assessment. You know, you may want to review the assessment to see, you know, what their present levels of performance are, to see what their strengths and their weaknesses are. Many times we have heard from parents that say they've actually identified a student that isn't my child. My child can't do this. You have the opportunity to say, I disagree with this assessment. And parents can disagree with the assessment and request an independent assessment. We're going to talk about that in a couple of slides. Next slide. So here we talk about assessments. These are some examples of assessments. Assessments may identify students' needs. And remember, when the school district completes the assessments, many times the assessments drive the type of placement that the student is going to have and the supports and services that they're going to receive. Assessments help identify the students' needs for occupational therapy, physical therapy, speech therapy, functional behavior, assistive technology, social, emotional, and behavioral needs, educationally related mental health services, a one-to-one aid support, and more. You can also ask for a mobility and orientation evaluation. You can ask for example, an assistive technology evaluation can cover an augmentative communication device. So these are really important. And many times they will not tell you what type of assessments they offer. Many times, and it's a matter of having that discussion with the IEP team, discuss what's happening to try to identify the different types of assessments that are needed. There may be a student that needs an assistive technology for, they may have a program for reading. These are assessments that the school district can conduct. Here we included a publication. It's a link to a publication, Understanding Psychoeducational Evaluations, and this is a great publication. Thank you, Raymond. So I mentioned a few minutes ago what happens when you disagree with an evaluation that the school district conducts. The parent has a right to request an independent evaluation at public expense. If you disagree with the assessment the school district did. The school district has two options. They either approve the independent assessment, or they would have to file for due process and show that their assessment was an appropriate assessment. Keep in mind that you can only ask for an independent evaluation once the school district conducts their evaluation. So if the school district does, for example, a vision assessment, or they don't, let's say they don't do a vision assessment, parents cannot go in and say, I want an independent evaluation for a vision assessment. The school district has to conduct the assessment first. Next slide. So the parents should receive in writing notice of an IEP meeting. The district has to provide written notice of an IEP scheduled meeting. If for some reason you cannot attend the meeting, you definitely, again, want to keep everything in writing. I say it's really important that you document. You let the school district know that you're not available if you're not available to attend the IEP meeting, and give them, 2 to 3 dates. They have to agree. There has to be a mutual agreement on a specific date and time. All I'm saying is it's really important to keep that communication open. Let the school district know if you're not available. Parents have the right to request an interpreter if English is not their primary language. And parents have the right to record the IEP meeting as long as you give the school district a written notice that you plan on recording at least 24 hours before the IEP meeting. Here we've included chapter 4 that talks about the IEP process, and I never get tired of saying the publications that we have are great resources. So I encourage people to look at the publications that we included in this PowerPoint. Next slide. So the IEP meeting, keep in mind that an individualized education plan is a legal contract between the school and the parent or the student. IEPs must be held annually and after an assessment is completed. When requested by parent or school, if requested by parent, the school must convene an IEP meeting within 30 days. The purpose of the IEP meeting is to meet with the parents to discuss all relevant assessments and information and design an offer of fate for the school year. In the individualized education plan is a legal contract. You want to also keep in mind that if they tell you verbally that something is going to be provided, make sure that it is written into the IEP. I can't emphasize that, enough, because we have heard where they have said verbally, we're going to provide this service, but if it's not in the IEP, it doesn't exist. It becomes your word against the IEP team. Next slide. How to prepare for an IEP meeting: include your child when appropriate. Make a list of what you and your child would like to happen for the school year. You may want to write down notes about goals, needs, and concerns that you have. Check in with friends and family to see if somebody can come with you to the IEP meeting. Provide the school with 24-hour written notice. If you intend on recording the meeting, you must take your own recording device. If you need an accommodation or an interpreter, also you may want to put that in writing. You may want to review last year's IEP. Look at the goals and objectives. Look and see where they're at, where the student is at in terms of a specific goal. Did they meet the goal? If they didn't meet the goal, ask those questions. Why isn't the student meeting the goal? Do they need some additional supports and services? Maybe they've met the goal. Many times we've heard where they keep the same goal for a number of years. So you want to make sure that you review the previous IEP as well. Review any assessments that the school has completed. Review any materials you have received throughout the year or the year before, including report cards, disciplinary records, and progress reports, or the student's work. That is really important to prepare for the next IEP. So who are the IEP team members? It's the parents, a special education teacher, a general ed teacher, a school district representative who has the authority to make decisions, service providers, which include occupational therapists if they're receiving OT, physical therapists, speech therapists, anybody that provides related services to the student. Person who conducted the assessments, they should be there to give a report on the assessment. And parent or a friend of the parent, if you plan on taking somebody with you, you're allowed. They should not tell parents, no, you cannot bring somebody with you. So if the parent wants to take a friend or an advocate, you should be allowed to take that person with you. Next slide. What must be included in an IEP? Eligibility, present levels of performance, any goals and objectives, related services. The related services should be very specific in terms of how many times a week, how many minutes. It's really important to specify the amount of services that are going to be provided. Any accommodations and or modifications, any behavioral plans, also known as behavior intervention plans, individualized transition plan if age appropriate. The transition plans usually start no later than the age of 16. And what they do, which they should do, is do an evaluation again to see where the student is academically, and talk about what it is that the student wants to do once they leave school or become an adult. What does the student want to do out in the community? What do they want to do? Do they plan on continuing their education? Do they have a vocational goal? This should be included in the transition plan. Classroom placement is really important. Any team notes, computerized system or handwritten notes. If the parents have any of their notes in terms of, talking about goals, any objectives, you certainly want, if you want to include those notes, they should be accepted as well. If the district will not let you attach your own notes, you should request that in writing, basically them saying that they're denying to include your notes, so you can then file what's called a compliance complaint. Next slide. Parents' rights at the IEP. Parents have the right to a meaningful participation at the IEP meeting. You should be able to ask any questions that you have written down, submit an agenda or any concerns that you have. Take time to think about what you want to talk about at the IEP meeting. Parents have the right to an interpreter at the IEP, free of charge. Again, you must request an interpreter in advance, and you should put it in writing. Parents may record the IEP as long as you give 24-hour written notice. Parental consent, an IEP cannot be implemented without consent. It's really important to know if it's the first time that the student is being assessed Just keep in mind that if you don't sign the certain areas, or if you don't sign the IEP, the services cannot be provided. But if you agree to service certain services, or if you agree to placement, you can sign the sections that you do agree with in order for those services to start. Parents have three choices. You can either consent in full, disagree in full, or consent to some parts and disagree to others. So you should document that in the IEP. Parents must receive a full final copy of the IEP. Do not leave without it. And the other thing that I think is really important to point out is make sure that the IEP pages are numbered. I think that's really important, to have the IEP pages numbered. If English is not your preferred language, you may request a copy of the IEP in your primary language. However, there isn't anything in the law that says they have a certain amount of time to provide you a copy of the IEP in your primary language. What it does say is that it should be, I can't remember the exact language, but within an appropriate amount of time. We think that 4 to 6 weeks should be enough time for them to translate the document. So here we've come to, it's right to file a compliance complaint. A compliance complaint is filed whenever they have either failed to comply with the procedures. For example, timelines. If they're not complying with the timelines, let's say, for example, you request an IEP and the IEP meeting is not being held within 30 days, that would be a compliance complaint. If they're not assessing within the 60-day timeline, that would be a compliance complaint. If the school district is not implementing the IEP, that would be a compliance complaint. You file a compliance complaint with the California Department of Education. File when special education laws or procedures have not been followed. CDE, the California Department of Education, must receive your complaint no later than 1 year after you claim the violation of special ed law occurred. However, you don't want to wait a full year before you file a compliance complaint. I think the sooner you file, the better. CDE, the California Department of Education, has 60 days to investigate, and then they send you a report. The education discrimination complaint, if there's discrimination based on disability, the Department of Education has a civil right. It's called the Office of Civil Rights. You can file a discrimination complaint there. Filing regarding allegations of discrimination on the basis of disabilities. So say, for example, they're going on an outing, and they say to one student, you can't go unless your parent comes, because the student, say, for example, has behaviors, that would be discrimination based on disability. A complaint must be filed within 180 days of the discrimination, and there is no timeline for that investigation. Next slide. Due process, there is a pre-hearing resolution. If the parents file for a due process, the district must offer a resolution, a meeting to try to resolve it. If the district files for due process, they do not have to offer the pre-hearing resolutions. Attorney for the district may not attend, unless the parents or the student is represented by an attorney. Must be able to discuss the basis for your complaint, and the district is given an opportunity to resolve it. All discussions are not confidential at the pre-hearing resolution and can be disclosed in a subsequent hearing or court case. Good practice is always for both sides to agree to confidentiality at that meeting. If there is an agreement, it must be in writing and signed by both sides. The agreement is legally binding on you, on the parents, and can be enforced in court. Either you or the district have 3 days after signing the agreement to revoke the signature. The resolution session must occur within 15 days of the district receiving the parent's request for due process. It must be finished within 30 days of the district receiving a parent's request. So this is a pre-hearing resolution. Next slide. And then mediation, there's an effort and attempt to compromise and come to a resolution of the disagreement. Both sides have to agree to mediate. It is facilitated by an independent mediator. Mediation does not change the 45-day timeline, although parents are sometimes asked to extend the 45-day timeline. And parents can still go forward with due process if mediation is not successful, or if there is partial agreement. If, say, you agree to parts of certain things at the mediation but didn't agree to other parts, you can still go to due process. What is said in mediation is confidential. Next slide. So here we've included some resources, the California Department of Ed, their website. And one thing that I thought was really important also is the Office of Administrative Hearings. Let's say, for example, there's disagreement in terms of a specific service, and you file for due process. So if you go to the Office of Administrative Hearings, you can look up some cases, say, for example, occupational therapy. You're asking for occupational therapy and the school district is denying you that service. It's really, I think it's a really good tool to look up any cases on occupational therapy and look at the decision that was rendered and what the judge used to make that decision. I think it's important to look at the facts in terms of what the parents provided because it indicates on the hearing decision. Next slide. I think we're done. So that concludes the presentation. I also wanted, if I may, Raymond, I'm going to go ahead and share our website. I think it's really important to. Can you see the website?
Yes, Mary, this is
Okay,
Judy.
great.
We can see it.
Great, thank you. So this is our website. You can select the language that you prefer. I'm going to click on English, but here we have self-advocacy resources, and it's by topic. So we have, in many areas, business and government entities, to California Children's Services, disability-related discrimination, employment, healthcare, Medi-Cal, mental health regional center, Social Security, and then we have special education. Down at the bottom here, we have 2 manuals. We have Special Education Rights and Responsibilities Manual, and then we have the rights under the Lanterman Act. But if we click here, I believe it's 16 or 17 chapters, 16 chapters, but it comes in a question and answer format. What I wanted to do, one of the questions, so I was given a list of questions from Myrna, and I also wanted to review those questions and provide some answers. But here we have all these chapters. Chapter 2 talks about the assessment process. Chapter 3 talks about eligibility. Chapter 4, the IEP process. And we also have in our appendix, there are sample letters. Sample letter for a referral for an assessment, sample letter for requesting records. And the good thing about the sample letters that we have, it cites the law. So for example, here they have 5 business days to provide parents copies of the educational records, and it cites the California Education Code. But there are a lot of sample letters. We also have a sample letter on filing a compliance complaint, which I think is very helpful. So it shows you what you should basically include, what you want as a resolution. Many parents, when, let's say, for example, if the school is not implementing the IEP, let's say they're not receiving speech therapy, they haven't received speech therapy in 3 months. What can the parents do when they file their compliance complaint is they can ask for compensatory services, meaning that they have to compensate them for the time that they didn't provide the service. So we have lots of publications here. There are, again, sample letters, patterns to look for. So I wanted to share this with everyone as well. If we go back to the special education section here, there are also toolkits, special education basic toolkit. We have behavior and discipline toolkit, disagreement toolkit, extended school year toolkit. And we also have many other publications, which, you know, it just has so much information that I think would be very helpful to parents. So I will stop sharing. And I don't know if now is a good time to take some questions.
I believe we can. We're gonna stop recording.